Morning. My name is Tony Calici. I am special counsel to FirstService Residential, and it's my pleasure to welcome you this morning to FirstService Residential annual legislative update. We're going to review the 2022 legislative session. The session began in January, ended on March 14th. It was a very important session in the community association area because of the impact of the collapse of the Champlain Towers south in Surfside, and also the skyrocketing cost of property in the state of Florida. We're going to pass during this last legislative session. Really, most of our focus will not be on what passed, since in the community association realm, there wasn't as much passed as we had anticipated. So we will spend a good bit of time talking about the things that did not pass, because the likelihood is that we're going to see them again soon, whether it be special session or in next year's legislative session. So we will spend a good bit of time on those important bills that did not pass as well. We will be recording today's webinar. It'll be made available on our website in the coming days, and we'll also be sharing our legislative alert with you as a resource. And we'll post it in the chat box. As always, we're going to be talking about things. We've got a great panel with us today. There will be some legal things discussed. We always encourage you to speak with your own association's attorney with regard to specific property-related questions regarding your community. Joining us today are two very well-respected attorneys that specialize in community association law. Long-time compatriots of mine, and we're happy to welcome them here this morning. First, Marnie Dale Reagan, a partner with Gursky and Reagan. Marnie, welcome.
Thank you so much for having me this morning.
And also Stephen Rappaport. Stephen is a partner in the Sachs Kaplan firm in Boca. And Steve, we're glad to have you here as well.
Great to be here. Thanks, Tony, and thanks to everyone for having me here.
Great. I'm going to introduce at this point my longtime friend and FirstService's legislative partner, Travis Moore. I have been working together on legislative for the last 20 years. And Travis always has tremendous insight to what goes on in the legislative process. Travis, welcome and take it away.
Thank you very much, Tony, and thank you to all of you that are joining us, taking some time out of your day to join us virtually. We appreciate it, and also, of course, as Tony mentioned, to our panelists, to Marnie and Steve, they'll be able to provide some real valuable insight to you. And every time we're together, I always learn some things as well. So appreciate them taking the time out of their day to participate. As Tony mentioned, the session ended, and every other year, it's between the spring and the winter. This year, it was an even number year, 2022. So they started in January, ended in March. There were about 3,000. There were 3,685 bills that were filed. We normally say about 10% of those actually get passed. And this year was a little less than that. It was 285 bills were passed. So a little less than the 10% that we normally see, but still certainly active. There were about 40 bills that FirstService was monitoring, tracking, working, various levels of involvement that we felt dealt specifically with community associations. And so we're going to talk about, we'll be hitting a lot of that today. Because as you know, working and volunteering and serving in community associations, there's a whole bunch of things that get discussed in Tallahassee that have an impact on you and your association. Even on a year where we weren't focused on some of the big building safety issues, things like certainly insurance, from flags, fines, all of those types of things were on the agenda in Tallahassee this year. So we've got a good agenda today. And as Tony mentioned, even though many of the issues most of the issues did not pass. We still want to talk about them because we will see them again. And also, a lot of these issues are just, some best practices type of things that associations, most of you are probably already doing, certainly should be doing. And so whether or not the law was changed to tell you to do them as a matter of law, we still think it's something that you should be doing. So we're gonna talk about those. Let's first of all talk about the bills or the issues that passed. So when the governor, at the first day of session, the governor always comes and does his State of the State address, very similar to when the president does the State of the Union address with Congress. And during that State of the State address, Governor DeSantis talked about the Champlain Towers disaster that occurred this summer. And he had some first responders there that we were very grateful, and the state was extremely grateful to have be a part of that rescue and recovery effort. And he recognized them, and then also said that the state was going to, in his budget recommendations, he wanted the state to contribute in the state budget $1 million toward a memorial that would be there in Surfside to honor those 98 souls that we lost. And the building and that community that is no longer there. So through the process, in the budget, there was that $1 million. The legislature did listen to that recommendation and put in, and we worked hard with the various appropriations chairs and staff and made sure that $1 million allocation is put in the state budget. So that will take effect July 1 is when the state's fiscal year begins and their budget year. So starting in a few months, July 1, that money will be realized in the upcoming 2022-23 budget. The other thing that we worked on very closely with Representative Woodson, Senator Ana Maria Rodriguez from Miami, was a piece of legislation that dealt with the abatement of taxes for a dwelling that was rendered uninhabitable due to a catastrophic event. So that language and the way it was tailored is essentially would affect just this particular property. And so that language that was in another bill, that was in a couple other bills, House Bill 71, Senate Bill 568, don't really matter anymore because it passed as part of the legislature's tax package, which was House Bill 7071. So that will go to the governor. Governor's expected to sign that. And then that language basically would go towards, essentially saying, Miami-Dade County property appraiser, you're not going to assess and have a property that was lost halfway through the year have to pay a property assessment on a building that A, no longer exists, B, was uninhabitable, people were displaced, so that will be of help to those families, those unit owners, the estates of those lost, so that they don't have to pay beyond the other tragedy that they obviously had to deal with, have even something, even worse, start getting bills from the property appraiser. So, or the tax collector. So that passed. And another bill that we'll talk about in a little bit more detail, but is a bill that dealt with trees and the pruning of trees in associations. It's kind of a follow-up to legislation that the legislature passed a few years ago. That's Senate Bill 518. But both of our panelists have some insight on that. We'll talk about that in our work that we did to try to kind of mitigate any damage, no pun intended, when dealing with these trees. But that bill did pass. Will be going to the governor, has not gone to the governor. It was a very high priority of the Florida League of Cities, and we'll talk about that. There were bills that we will discuss, and I'm just going to mention them real quickly, that did not pass, but you read all about them through the process, not only from us, hearing on our regular weekly updates through session, but also in the Miami Herald, Sun Sentinel, your local paper, because there were bills that were dealing with the Surfside issue and with building safety and reserve studies, et cetera. That the House passed their bill. The Senate passed a bill. So, you know, when you read in the papers and a different information, you know, oh, that this bill passed, it was referring to passing certain, you know, a chamber of the legislature. But the way obviously a bill, how a bill becomes a law, the identical language has to pass both houses and then go to the governor for his approval. And that did not happen. So even though you may have read, you know, starting in 2024 or starting in 2026, we're going to need to do this, we're going to need to do that. Again, by law, those bills did not pass. So we'll talk about them, talk about some bills dealing with the rising insurance costs. That's something that is affecting all of the associations. Those efforts to reform that did not pass. There very well may be, as Tony mentioned, a special session dealing with those issues. The vacation rental bill did not pass. We put language in that would have protected associations had it passed. So we would have been safe either way, regardless of whether or not vacation rentals were going to be controlled by a local ordinance and on the local level or the state level. Associations rules and regulations and our documents, your documents would have been able to still prevail, however you decide to handle that. So, but the bill itself did not pass, so nothing changes there. And then there were bills that were dealing with the fining process, dealing with flags, limiting an association's ability to regulate flags being flown in their community, adding all kinds of new processes to how the fining process would work if you fine for violations of your documents, et cetera. So those bills, none of those passed. So what I'd like to do is let's start with, well, is there any comment from either of our panelists on either and then we'll use this as our launching point to get into a larger discussion about the Champlain Towers, so, you know, the Surfside response legislation that didn't pass, but is there any comments regarding the property tax issue, the memorial, anything along those lines before we go forward?
I would just go ahead, Steve. Sorry.
Well, I think you wrapped up the abatement and the memorial issue very well. I think the tree issue specifically is one that's very important to me because I deal with it on an almost daily basis, especially with our clients out in the West Delray, West Boynton area, dealing with street trees and things like that. I mean, to give a little background on how we got where we're at with this, and I don't remember if it was last year or the year before, but the legislature put into effect a bill that passed a couple years back that said that if you have trees on residential property that are a danger to your property and you have an opinion from a certified arborist or a licensed landscape architect or whatever the expert is that says that these trees are a danger to your community, that you do not have to go through the permitting and application process of your municipality, whether it's city or county, in order to address these trees and to mitigate this damage. And it was a good bill, although I understand that some of the counties and cities were interpreting residential property to be only the homeowner's individual lots. I happen to think that is a wrong interpretation. To me, residential property includes association common areas. I mean, we're not commercial property, we're not the mall. So to me, I've always interpreted the law as saying, hey, if you have street trees in your common areas or any sort of condominium common element or HOA common area trees that need to be addressed, and you have an expert opinion saying they need to be gone, you should be able to remove them and not have to go through the red tape and the burdens of a permitting process. Well, we wanted clarification on this because there was no definition in the law as to what was considered residential property. And now this law that's been passed and is pending the governor's signature actually does clarify it and clarifies it in the wrong way, I think, by saying that residential property is deemed to be the individual homeowner's single family homeowners lots that they own. So if this does get signed by the governor, and Travis, maybe you can comment on what the process is and whether you think there's a chance of veto, but as of July 1, we're going to be in a situation where now our HOAs, they're going to have clarity that our condos and HOAs are not going to be able to get these trees removed without going through the permitting and the application process. You'll still be able to get them addressed and removed, but you'll have to go through all that burden that we don't think you should have to go through. So it's a bad law.
Correct. And just from a process standpoint, I mean, the bill, as you said, I mean, it essentially did three things, two of which would been fine and great if it did the third thing. And the one of them is just saying, here's the documentation you need to have from your arborist to prove that this is a danger to property or safety to health. to somebody. And then the other thing is, when you have this inspected by this registered arborist or certified arborist, you can't do it virtually. It has to be an on-site in-person inspection. But then it says, okay, and if you do that, then you as a homeowner, and it defines, residential property, as Steve said, as just a single family home, you don't have to go through the, getting a permit, doing a mitigation. If you take out one tree, you got to plant 3. You don't have to go through all of this red tape that local government was putting on you. So we argued in committee numerous times before, with these sponsors, that, hey, we're not residential, as Steve said. We are not commercial, as Steve said. We are clearly residential. There's Supreme Court case law, that says associations are residential in nature. We're the ones that the residents pay for the trees, manage their trees, deal with their trees through their association. And so we wanted it extended to include 718 for condos, 719, 720, that association trees that are owned by the association the association could afford themselves or avail themselves of these tools. And there was pushback from the city and cities and everybody, no, this is going to open it up to apartments. It's going to open it up to all kinds of businesses, to mobile home parks, et cetera. And we would argue that's the beauty of having statute numbers, because you can put in and be very specific about what you're opening it up for. So that bill has not yet gone to the governor. It passed. It'll be sent to the governor any day. When the bill goes to the governor, he has 15 days. He or she has 15 days to sign it or veto it, or it just becomes law without his signature if they don't veto it. So I would urge you to contact the governor's office, and in email, call. Those numbers are all available. We can get them to you as well. To say, as an association, you would like that vetoed, because I think that they would have to take another crack at it. If it gets signed, we're going to certainly go back to try to change that definition, but it would force them to deal with us if the governor said, this is going to add a lot of expense to associations, and just vetoed it. So that's that bill. Let's move on, because I want to talk about the condominium safety reforms that were being looked at by both the House and the Senate in response to Surfside. So Marnie, could you kind of walk us through some of that, and then we'll kind of use that as our jumping off point.
Of course. And good morning again to everybody. And I want to thank initially FSR for putting this together, and Travis for doing all of the homework. What he's doing has been great, and it's a huge tool for practitioners and for homeowners alike. What I've been tasked with this morning is to discuss with you what did not pass. And I'm going to say that 3, 4, 5 times. And inevitably someone's going to email one of us next week and say, so tell me about the bill that passed. That being said, some version of this is absolutely going to pass, and it will in the near future. And so my best advice to anybody listening this morning is to listen, to kind of take notes potentially, or get a copy of the bill and have an idea of what it says, and start making sure that your community is planning accordingly. This will pass in the future in some way, shape, or form. Some of the timelines may be different, but it certainly is going to have a huge impact on condominiums and co-ops. I'm going to center it more on condominiums, because I think that's probably more of our audience this morning. But it's also going to have huge financial ramifications based upon the necessary steps that these associations are going to have to take. First and foremost, what this legislation offered, and I'll also say I think it's very disappointing that something didn't pass this year. But again, I'll reiterate, it will in the future. A new portion of the statute was going to be created, and it was going to create an obligation for what's called a milestone inspection. These milestone inspections are going to look at load-bearing walls and structural aspects of the condominium. That's got to be done by a licensed engineer or architect. You've got to put a report together. There's 2 phases of that inspection. The first is the initial inspection, and the second is what you got to fix afterwards. Once that first portion of the inspection is completed, it's going to have to be memorialized into a report. That report's going to have to be delivered to the membership, put on your websites. delivered to your municipalities. So there's those expenses and steps that are going to certainly have to be taken. It's going to then have to be folded into your reserve study and mailed out with your annual meeting packages for your budgets when you go to approve all of your budgets. So there's a lot of steps and a lot of cost that's going to be flowing through that. Then if your milestone inspection is such that you have repairs that need to be made, you have a process by which you're going to have to comply with those repairs in order to continue forward as a condominium and to not have violations or people breathing down your back. Now, the caveat to this is there's two different standards, I guess you would say, for condominiums and how this would be applicable. In the past, there's been a 40-year and a 50-year recertification in Dade and Broward alone. If you're in the Panhandle, if you're up in towards Jacksonville, none of this ever really applied to you other than being, smart, intelligent, reasonable, and being good fiduciaries. Now, if you are within 3 miles of a coast, you're going to be required to do this when your condominium turns 20. By the time December 31st, your condominium is turning 20, you're going to have to do this, and you're going to have to do it every 7 years thereafter. If you're outside of that 3 miles from the coast, if you're farther inland, you have to do it before your 30th birthday, and then you have to do it every 10 years thereafter. And again, these numbers are part of a bill that did not pass, but I would suspect that somewhere in there is what the legislature is going to be looking at going forward. You're also going to have a reserve study. That reserve study, I would suggest, is going to flow from that milestone inspection. Have your engineers, records, your architects put together a reserve study for you. That reserve study is going to have to be addressed more strongly than in the past. It's going to have to be mailed out with your budget. Typically in the past, you could have a reserve study. It was made available upon request. Great. Now this is something that's going to have to be done. It's going to have to be done continuously. I believe it was every 3 years in one of the copies of the bills that I saw. And all of this had to be undertaken by 2024. So yes, it was 2 years out. However, if anyone in this call has been trying to get a hold of an engineer or a licensed architect lately to get some help, you've seen what the lines have been like. So to that end, I think it's extremely important that while this didn't become law, if you're a wise fiduciary of your condominium, I would suggest starting to get in line to at least get the reserve study undertaken. Start taking some of these steps. Take those snapshots of your building. And that way you have a better idea of what you're really looking for. If you're close to your 40-year within the next year or so, I would jump on it now if you're in Dade and Broward, because that's something that's just going to get more difficult to meet those timelines. There's other aspects of that bill that are tied in with it that really relate to the ability of these associations to operate. Again, you have this reserve study. It's going to have to be mailed out with your budget. The disclaimer language relating to the waiver of reserves that's been required for the last probably 10 years has been altered to make it kind of more threatening. It's something that you've got to consider. The levels for waiving reserves has typically been a majority of a quorum. Now it's being flirted with whether it be 2/3 or a full majority at least. So it's going to get more difficult to waive your reserves. May or may not be a bad thing. However, there is a financial impact to that. The reserve study itself and what's required to be included within your reserves is no longer the simple painting, roof, elevators, and pavement. It's actually all of your structural components. So that reserve study and what's required to be collected is expanding. Again, a financial impact. So we certainly don't want to scare anyone, but I think that the board members certainly really need to be cognizant of what's coming up for them and how they're going to have to address these things. If you've been fully funding reserves, great, you're ahead of the game. But if you haven't been, I think it's even more important that these reserve studies be undertaken before this becomes law. Get ahead of the curve, start to have an idea, and start to tell your membership what's coming. I think there's a misconception for a lot of condominium owners that they pay their assessments, everything's good, they're not going to be specially assessed. And that's not the case. Whether you're in a home or you're in a condominium, the reality is you're going to pay now or you're going to pay later. Everything has to be maintained. And so if you can get memberships to understand that this is the care and maintenance of the building, not only do they want to do it, but they have to do it. And now there's going to be far more mechanisms to make sure that that happens. One of the aspects of this bill that I really did like, and I'd like to see translate over into past legislation, is some of the hindrances that are put on boards when they're trying to make these repairs. it's being made very, very clear that maintenance, repair, and replacement is not a material alteration. It's not a substantial improvement. And it's something that you're not going to have to go to the membership for a vote for. In addition, if an association board of directors needs to specially assess, or if they need to borrow funds to make these repairs, anything that relates to that milestone inspection, you don't have to go to your membership anymore to get that vote, regardless of what your documents say. I think that's very important. I think that's a huge tool for these associations, because it's hard to ask people to spend money they don't want to. And when you have to have their approval to proceed, it's a political dynamic that's very difficult, because the board that always seems to win elections is the one that says, I'm going to keep your assessments low. It's just not feasible. It's not feasible in today's world. Nobody ever wants to see what happened this past summer happen again. And the legislature, I think, is making it much easier for boards to operate without, whether it be the guilt or the politics behind it. You're going to have to do this, and it's going to be an easier pill to swallow for members if the legislature is telling them to do it, that they have to do it, as opposed to you as board members sitting up there, because your elections are every year. It happens, and it's very political. So I think that portion of the bill is very good. I like it. I want to see that approved. It's not that I don't want to see the milestone inspection improved, but I think that there's got to be some balance on the financial impact. I don't know that every 3 years for reserve study is necessarily required. Maybe it's 5. I don't know. The legislature flirted with this probably 10 years ago now about requiring reserve studies, and they pulled it out the next year. So it's a matter of what they're going to do, but it's going to stick this time because of what happened. All of these requirements, whether it be milestone inspections, whether it be maintenance repair, all of those items are being added into dispute resolution portions of the statute. And you may say, well, what's the point? What it is it's a mechanism to allow owners to make sure that these associations and these boards are doing what they need to do. So if you get a board that's reluctant to do these things, an owner can file this complaint. They're going to have standing to raise it that the association is not doing what they're required to do by statute. I know that's a lot to kind of digest, and I don't want to belabor it again. It didn't pass, but it's going to. And it's just extremely important that anyone on this call is starting to almost treat it as if it did pass, and start looking that way, because again, a version of it will be passed in the future. I would actually ask Travis, because he saw the differing versions of the House and the Senate bill and how it grew. I'd want certainly him to kind of speak to that, and Stephen, feel free to add anything that I missed.
Thank you, Marnie. And Stephen, before I launch into some things, and also we'll address some of the questions that we had coming in, because it's just a part of this discussion. Do you have anything to add to that?
I mean, my biggest concern with what happened with this particular legislation, and I agree with Marnie, I mean, certainly something's going to come down the pike. We're going to have to deal with some sort of inspection requirement, some sort of reserve study requirement, and probably have some type of restriction or tightening of our ability to waive or reduce reserves in the future. I think where I had the biggest concerns was with the House version, where they were completely taking away any flexibility in the reserves by completely taking away the ability to waive reserves at all. And I think they were also even contemplating taking away the ability to pool reserves, which I'm not sure how, maybe on a moving forward basis in 2 or 3 years when we're able to get ourselves together to do that. But how do you unpool reserves that you've already collected through pooled reserves? And I think they're missing the whole point of pooled reserves, and the flexibility and the benefit of that is to be able to deal with these Surfside type issues. I think we want to be able to have our reserves pooled so that we can use any of our reserves for these important purposes. So I think they completely missed the boat on the pooled reserve issue, and we need to make sure in the future versions of these bills that we have some flexibility and that we don't lose that option. But also in the inability to waive reserves, again, I absolutely believe we are going to see something along the lines of maybe requiring a majority vote of the entire membership as opposed to majority of the quorum, or something that makes it a little more difficult to waive reserves. But to take away that complete option, I mean, I'll just give you an example of a meeting that I was in before Surfside even happened, where I was sitting in a meeting where they were contemplating waiving reserves, and there was concerns brought about what are you doing waiving reserves? We're going to have a special assessment in 5 years or 10 years to do this. And there were some people in the audience that said, hey, you know what? I would rather take my money now, invest it how I want to invest it, in the market or wherever. And then when you need a special assessment in 5 or 10 years, I'll have more money then to be able to pay that special assessment, as opposed to you forcing me to pay into a reserve fund that you're going to have to keep in some money market account for 0.0025% interest that's going to sit there for 10 years. Let me do what I want to do with my funds. So again, not everyone's in that position, but I think it's important for us in any of these pieces of legislation to realize that one size doesn't always fit all for all of our associations. What's good for an HOA may not be good for a high-rise condo. What's good for a condo in the East Coast of Florida might not be good for the Panhandle, and so forth. So I think any of these laws where you're forcing some outcome that takes away flexibility is a bad thing.
Agreed. Okay, I'm gonna go into some real quick explanation that's kind of behind the scenes, et cetera. But number one, I agree, and I agree with what Marnie said is, and I'm going to reiterate, because I can already tell people are thinking this passed. Did not pass. Did not pass. Let me say that. However, for the reasons that she said, just as best practice, just because, and we're going to talk about this in a second, but the private sector, from lending institutions, insurance requirements when you're going to get your insurance renewed, they're asking for things now. So the private sector is moving a lot faster on these requirements. So that's there. It's going to, some level of this, some type of this will pass, as Marnie said. Whether or not it's in a special session, if they can come to an agreement, they could add it to any special session type of a thing if they so choose. If not, it would be next year. And then the other thing is that even if this had passed, it was not, as Marnie alluded to, wasn't going to take effect until parts of it were going to be in 3 years, parts of it were going to be in 2024. So there was going to be an intervening 2023 session anyway. So what they'll do is they'll just pass it, and instead of kicking it out to 2024, it'll just take effect that much sooner. So essentially, we're in that process right now. We can think that of that interim phase of making sure we've got all of our things in order. Because this is something, different than I know many of you have dealt with on the fire sprinkler thing, where they kind of kept kicking the can down the road on fire sprinkler, the engineered life safety system stuff. This isn't going to be that. They're not going to kick it down the road, that much. I mean, they'll give time, but it's something that you need to be preparing for. And again, like I said, the private sector is already asking for it. So real quick, before I go into some other things, I'm just going to answer some of these questions because it goes to this. And I'm going to start with Dennis, where it says, does 3 miles from the coast include properties within 3 miles of the bay, for example, Tampa Bay? If it's salt water, the answer is yes. It includes, the concern was that salt water and saltwater intrusion and the environment of saltwater air, that's what accelerated some of the, accelerates erosion. Again, this is coming from the engineers and the architects. We are not that, but in their report. So that's where that came from. So if it's a river, a lake, middle of the state, no. But if it is what we think of as the beach, and certainly, Tampa Bay, and there's some other, Key Biscayne, whatever, that type of, intercoastal, if it's salt water, then you would be in that, within the 3 miles of the coast group pot. We had a question we're going to talk about in a second here from Jackie Grant regarding Fannie Mae, Freddie Mac. We're going to talk about that in a little bit more about getting caught up in this and some of their requirements. They were waiting to see what Florida did. Florida didn't. So some of that stuff's gonna take effect. Chris Armstrong asked about the electronic communication of the new Milestone. This was something that we'd worked on, and Tony and I had worked on specifically together. So we said, let's assume that with all the appendices and everything, that this report is, a few hundred pages, and you're having to send this out to 100 and some unit owners by mail. That's going to be a big expense of postage that could be used, that's not being used towards repairs. It's not being used towards anything regarding safety. So we said, So what the part of the give and take was, okay, well, you could do an executive summary. And then we went back and forth. We said, look, we don't want, I mean, there's some of you guys that are and gals that are experts and are engineers, and you probably could look at 100-some page report and say, and come up with a 1-page executive summary and say, this is what we need to do, but you shouldn't have to. And quite honestly, I don't want association boards deciding that. So what should be included in an executive summary and making that interpretation? So we went, and in the law, it would have said, or in the bill, so it would have been the law said that a executive summary, a 1-page executive summary would be prepared by the engineer and architect that did the report. Part of their responsibility would be to provide the association with an executive summary. That's what would have to be provided either by mail and electronically, as Marnie said, posting on the website, et cetera. The House was saying, no, we want the whole thing going. We don't care. We don't want it to be electronic. We want it to be the whole thing. Their argument was, this is something that you're only having to do once every, say, 10 years. You can pay to have this done. So again, and that was one of the disagreements, but that we think that a version would allow for electronic. We think if something goes, that it'll allow for electronic distribution of the executive summary, or at least just the mailing of the executive summary, not hundreds of pages of documents. Again, one of the things that Marty kind of mentioned is a big part of this for the Senate in particular was disclosure to not only all unit owners and renters, but also to the city building officials, but also to prospective buyers. So part of this would be included. I'm not a environmental engineer, so I'm going to not deal with some of the things asking about brackish water. It was the coast, meaning a body of salt water. So I'm going to probably say no on brackish, but again, we'll let you work through that with your counsel. Dennis asked real quickly about, and this is something that's important about the minimum number of floors. Yes, this would impact associations that have 3 or more floors. So if you're a 2-story garden style, wouldn't have affected you. Again, you can, yeah, I think it's important to have reserve studies and such. Anyway, that's a good thing to do, so you should do it. Patricia was asking about, will it affect small condos? It didn't matter. If you have a condo that is 3 floors or more, it would affect you. So everybody put forward and the real property section of the Florida Bar, the engineers, us, everybody put forward reports, recommendations, and said, here's these recommendations we think should happen. The Senate took those recommendations into basically 2 bills initially. The House didn't do anything with it to start with. And then their bill was created and showed up on Valentine's Day. And from the day it was showed up as a proposed committee bill and went through one committee, it then was voted out of the House all within 2 weeks. 13 days. So they moved very, very, very quickly. A lot of the differences were on, things that they could have agreed on, didn't limit. Like one had it at 30 years and then 20 years. One had it at 30 years and 25 years. So the Senate said, fine, we'll take your 25 years. But the other issues that were bigger were on like the reserve study stuff. The House wanted to include things in for their reserve study that would be, so your reserve study is a financial tool, planning tool for things that are dealing with structural items of your building that have a remaining useful life. So let's use your roof, for example. Your roof is they're gonna say, okay, this roof is good for a number of years. So okay, in this number of years in the future, we're gonna have to replace it. So how much do we have to save, count for inflation, et cetera, to be ready to replace our roof? One of the things, as Marty mentioned, they added a whole bunch of things. Some of them like foundation. Your foundation doesn't have a remaining useful life. your foundation is supposed to last forever. I mean, I don't know how you go in and determine what your, I mean, let's look at like the breakers up the beach from where this tragedy happened. I think the breakers is like 186 years old. Foundation is still hanging in there. So I don't know. So it's things like that. I don't mean to be flippant, but I don't know how you don't have a remaining useful life of your foundation. Like what do you know, how are you supposed to save for that? So those types of issues, we also had argued, look, we're, you know, association experts, attorneys, we are not engineers and architects. Let the engineers and architects determine what the components are that make up life safety and these life safety issues. And we have the Florida Building Commission. Let's kick that to the Florida Building Commission, which is what the Senate bill did, and said, let's have the Florida Building Commission take a look at what constitutes life safety items and what you need to be reserving for if you want to just be reserving for life safety. They also had things in there, as Steve mentioned, not allowing anymore. You cannot use the pooled reserve method. You had to use straight line counting. That in a lot of ways, I mean, over 67% of Florida's associations use the pooled reserves, and more are going that direction. As Steve said, I think it's just a misunderstanding about how it works. I think it provides flexibility. They to address concerns, their whole philosophy is they don't want boards to have any flexibility. Their concern was, you're going to use items that are in this for things like to lobby, to carpet the lobby. And, you know, that's, again, that's how well do you trust association boards as adults running corporations? And how much do you want to micromanage whether or not how their accounting is handled? Going back real quick, I just remember on the issue regarding one of the reasons why I said I don't want to be the one deciding what the life safety features are of a building is because if I was looking on June 23rd, I for one would have not have put the pool deck as a life safety issue. I would have never said, you know, that pool, the pool, let's look at, and that would have been missed, obviously, from the looks of things. That is something that very much was part of the reasons why we had a structural collapse. So again, that report's still ongoing with the federal government, but that's, you know, that's something that I'm like, let the professionals deal with that. They also didn't want, as Steve mentioned, they didn't the difference is the House didn't want any waiving of reserves at all. They didn't want you to be able to waive them. Florida it's the threshold is too low. As Marty mentioned, it's just a majority of a quorum at a meeting. That should certainly go up and be much more unit owner involvement to waive reserves, but they wanted it to go to where it would be there was no waiving of reserves. So as they were working these out, sorry.
I was just gonna say a term that was tossed around a lot during the during the legislative process was glide path. And
right.
I had never really heard that term, but with respect to reserve accounts, you want to elaborate a little bit on that and that difference between the two versions?
Yeah, we said if you're going to get rid of pooled reserves, if that's your decision to get rid of pooled reserves, to Steve's point, you can't just do it overnight. And the way it would have gone to effect July 1 of 2022, this July. And I said, that's also right in the middle of an association's budget year. So they gave a glide path of, we're going to make that 3 years down the line so that you wouldn't have to, and starting in 3 years, you could no longer use pooled reserves. Things like the no longer waiving reserves would be in 2026. The building inspection stuff would start, would give you a year to start some of that because we needed the ability to get, so the glide path was, kind of this, we're going to set this date in the future and allow you to kind of get to it. As the House and Senate were negotiating this, the House had sent over their bill. The Senate had everything combined into one. They decided they came up with a draft and showed it to the House and the House staff and the House sponsor and everything. And the House said no. So then they kept going back and forth. And every time they would send something over, the House would say, no, we're not moving off of our stuff. So what the Senate decided as session was running out, there was 2 more days. They said, all right, we know we have agreement on building safety. That's the only thing we know we have like agreement on is the building, the milestone inspection stuff, or the recertification is what, certification is what the House was calling it. But we'll give them, the Senate said, we'll give them the 25 years. We'll make it 30, 25, and we'll have, so they stripped everything back except for what they thought they had absolute agreement on. And they said, we're going to send that over. And the Senate will either say, all right, well, this we agree with and pass that, or the House will send something back. And we'll the way the rules are, if they send something back in this returning message, the Senate would just have to take it or leave it. And that's what they were contemplating doing. And they sent over their version to the 2 days before session. And then the House said, nope, we're not doing anything. And that's what, and then and for their own reasons, I mean, that's between them. But they decided no. And so that's why nothing passed. And right now, those 2 parties are still talking and negotiating and trying to come up with something. Last thing I'll say on this is that the Senate had made the strategic decision because they didn't want it to get involved in all the other condo issues that are all out there and all the other things. As I mentioned, there were 40 bills dealing with condo associations and community associations. They picked the senator that doesn't have any condos in her district. Last year, her big bill was a sales tax exemption for farm equipment. She didn't have any, so that it was just going to be building safety. And initially, their building safety, they were like, a building is a building is a building. If it's a residential building, so it affected apartments, it affected hotels, it affected anything. But the House didn't want to go there, so they scaled that back. But that's their approach was, trying to come up with that. The House, had decided we want to have somebody involved that is very much a part of where this tragedy occurred. So they were looking at it very much from a Miami perspective, and again, not going to quibble. That was the difference that we were dealing with, and it became, for them, the differences just became insurmountable. And I think now, though, that there's all this, there's concern, as Marnie said, a lot of confusion and concern as to why nothing was done, I think now is generating some pressure to get something done. There's a question in here about, will these new reserve study requirements become matters for audit? Again, David, that's a good question. Certainly whatever I would assume so, but again, that's something that I would say your financial planners and CPAs and lawyers would probably need to better answer, because I don't. So
the start date for determining the 20 years or 30 years or whatever for the inspections, CO, is that what?
Right. Well, there's the one here from Nick. Are all requirements exempt below 3 stories? Yes. What is defined as T0 for the periodicity of the inspections?
I think the question was, what's the start date to determine when you need your first inspection? Does it run from when the CO was first issued?
Yes. It's when the certificate of occupancy, it's different than which another bill we're going to talk about here in a second, construction defects, which is at turnover. This is when people started living in the building. So it would be your certificate of occupancy.
I can jump in real quick
Becky,
on
I'll
that.
answer your question offline at some point.
What I have seen, though, is if you don't have that CO, if you're an older building, I would definitely go from at least the date of recording, because at least you have a time certain. And it may not be the CO, but at least you would have a better idea of, you would know that you're in compliance at that point.
Right. Kirk, nothing passed. So there won't be a webinar addressing what passed regarding HOAs, except for the tree bill. again, the tree bill. Now, we are going to have a quick discussion about a bill that passed last year regarding long-term rentals, which we could probably do now, that might help you be some information that you need, that because it passed, like I said, last year, just went into effect last July, so almost a year ago. So it's relatively new. So we can talk about that in a second. So hang on. Marnie, real quick, do you want to talk about the Fannie Mae and Freddie Mac issue?
Other than it's a complete disaster and it's bogging associations down horrifically. Sure, I understand what they're trying to do, and I don't have a problem with it per se. The problem is that when you look at the sale of a condominium unit, it's all the records are due to the seller. Purchasers are only entitled to certain records. So now you have lenders on behalf of purchasers seeking all of this information. And it's not that I think that associations aren't looking to not comply. It's more that what they're being asked to answer is very time consuming, and it opens up the door to a lot of liability. So all of a sudden association attorneys are getting engaged in answering these questions as well. The typical range of questions, if you're not familiar, is: are there reserve studies? Are there plans for deferred maintenance? Are there outstanding violations? Are there outstanding projects? And you have to start strategically answering these questions in order to protect the liability of the association. You want to be as truthful as possible, but oftentimes when I end up going through these, and I recommend, if the end recommendation is talk to counsel about it, you have to, is to make sure that you're answering the question and only the question. It's kind of like, if you've ever been in a deposition, don't tell a story, just answer the question. Only produce the facts. If you have a reserve study, they want it produced. And again, the fundamental problem goes back to owners are entitled to this information. Purchasers aren't necessarily entitled, but nobody wants to be in a situation where they're obstructing sales. So it ends up causing a bit of delay, and it also causes expense. And the question is, whose expense is it? And I don't know that there's been a square decision on whose. I think a lot of associations are trying to pass that on to the purchaser as an additional estoppel requirement. And it certainly is problematic. I don't know what's going to happen if the legislature is going to try to step in. I don't know that they can, because you're talking about federal mortgages, but it certainly is problematic. The best thing that the associations can do is just try to be compliant, but be very cautious how you answer those questions.
Thank you. And I was answering some of these questions, typing answers back. Real quick,
Travis, you're involved with CAI as well.
Correct.
I know CAI has been advocating on a national basis to try and address the issue with regard to the Fannie Mae requirements.
Yes, they've been meeting in DC with them and are working that issue up there from a federal level. Correct. Because that impacts, that's not just a Florida, that's a nationwide. Yep. Construction defects, Steve, let's go to that, and we'll still get back to some of these questions, but let's hit that if you can. Thanks.
Yeah, so the construction defect bill that came out, I think there were two. It was in the House, I believe, 583 and 736 in the Senate, and it did a number of things. One of the bad things that, at least in my opinion, I think bad on the earlier versions of it, was to get rid of the 558 process for construction defects for our associations. I don't do a lot of our construction defect work. I leave that to our litigation partners. But from what I gather and from my experience, 558 is a good process. 558 works. It works very well. And by the way, Travis, you might want to think about this when talking to your contacts up there in the future. But what do the optics look like when the first legislative session after Surfside, they're talking about making it easier for developers to get out of dealing with construction defect claims for associations? I'm not sure that's the best thing that they could have tackled right out of the gate. But needless to say, the bill that, like the others we've been talking about, did not pass. So 558 is still preserved, at least for now. But that's something we'll have to deal with in the future to see if they try to tweak it, try to get rid of it, have some sort of replacement process for it. The bigger issue, and especially for HOAs that we ran up against when dealing with this bill, was also the statute of repose for an HOA and bringing a construction defect claim against the developer. Right now, I believe it's a 10-year statute of repose for condominiums and homeowners associations, and that was going to remain the same for condos under the pending legislation. But there was some language in at least it was in 736, that seemed to make it clear that they were reducing that down to about a maximum of a 5-year statute for single family residences and related buildings. And it wasn't clear from the drafting of the language whether that included the common property buildings for an HOA or just the individual homes and lots. There was a catch-all provision that went back to 10 years for anything that wasn't specifically identified. But again, it wasn't clear because of that single family home language. Did that mean the clubhouse or the common property for an HOA was going to be governed by a 5-year statute as opposed to a 10-year? And that's a problem because for many of our HOAs, you're talking about 5 years from the CO and from inception. A lot of our HOAs don't turn over until sometimes 6, 7, 8 years afterwards. And you're talking about a bill that could be argued to have completely taken away that HOA's entire remedy to even bring a claim against the developer in the first place. So we really fought hard on that. And I think in the end, they did finally address that issue, but ultimately it wound up getting killed, which was a good thing, because again, better to have no legislation than have bad legislation. But I'm sure that's something that's going to be brought up in the future. And I think we need to keep that in mind and make sure whatever they do, that they keep the statute the same for HOAs, condos, and co-ops, and make it clear in the language that there's no way to argue around that.
Very good. All right. All right, I could keep typing on this. I mean, I feel like a tween over here, just typing away on these chats. Okay, I mean, a lot of good questions.
Travis, one thing we didn't really touch on because it does have kind of a limited geographic impact, but Miami-Dade County and what they did by way of ordinance requiring, supposedly in the interest of transparency, requiring
Right.
detailed filing requirements for community associations, condos, HOAs, co-ops. Anybody want to comment on that? Or, I mean,
Marnie?
Go back a little bit, Tony, because I got distracted for a second. I apologize.
Marnie, we're just talking about the Miami-Dade County ordinance that was adopted that requires, detailed filing by associations. And I think February 1 of next year will be the start date. So there's a little bit of ramp up time to start putting all that in place, but very detailed information. And again, most of this stuff, or almost all of this stuff, is required to be maintained as part of the association's official records. But this goes a step farther and requires that all of this stuff be maintained in a public database that anybody could access. The names of directors, their contact information, insurance policies for the association, capital projects that the association is going to be involved with in the future. So it seems extremely burdensome. And to my knowledge, this just kind of went through. I don't know that anybody was actively involved in trying to oppose it, but it creates a real burden for Miami-Dade County community associations.
It definitely does. And again, I apologize. I was reading all of the questions, which, by the way, are wickedly intelligent. They're right on spot, and there's not a whole lot of answers to give because there's not enough specificity in what's been thrown out so far. Yeah, this new ordinance is crazy. It's clearly a knee-jerk reaction. It's not necessarily bad, but it is burdensome. I think a lot of it stems from after the initial collapse, everybody was looking to point fingers on who should have stopped it, who should have known, who should have said something. And so it's a response to maintain the buildings, which is fantastic. But the level of spreading out that information to whether it be municipalities, whether it be random individuals, is really getting out there, and it becomes very burdensome. I represent some office condominiums where trying to get them to do the basic general maintenance, paying attention to their building because they're running their businesses out of there is hard enough, and especially when you get into a downtown area, there's actually quite a few office condominiums. So. And that was actually one of the first managers that contacted me about that and said, well, what do we do? And so my first response was, get in line for the engineers, because that's who you're going to have to engage. And I think if anyone's looking for a job right now, that's the best way to go, because they're going to be in tough supply for a long time. But, Tony kind of hit on what's going to be included, but it's extremely cumbersome and it's very detailed. And again, I think it's just a matter of spreading out all that information as far as they can go. I don't know that it really is beneficial to do that, because at the end of the day, the owners of the condominiums are the ones with the highest interest in the property. So we'll see what happens with it.
Thank you, Marnie. Real quick, I'm going to, so that you can get a drink of water. I am going to switch order for a second, come back to you on insurance, I want to go to Steve real quick, unless you answered this while I was typing something, which I think I got all the questions answered. Steve, on vacation rentals, long-term rental restrictions for HOAs, so that this goes to our friend, I don't know who it was, Nick, somebody,
Yeah.
that was asking about HOAs. Again, this passed last year, went into effect last July, but it's relatively recent. So why don't we talk about that real quick?
Right. So first with the vacation rental bill, because this has come up now maybe 3 or 4 sessions in a row, and it never seems to pass, but I'm sure at some point it will. The general gist of the vacation rental bill is that it preempts to the state regulations over vacation rentals and says that a municipality, city, county cannot by ordinance regulate vacation rentals. This was a problem for us at first because it originally did not have language that would carve out the exception for our associations. But the current versions, last year's late version and this year's that was killed, did still have the language in it that irrespective of the inability of a county or city or other municipality to regulate vacation rentals, this would not affect the ability of an association, either a condo association, cooperative, or HOA pursuant to 718, 719, or 720 from amending their governing documents to deal with these issues. So it's, I don't personally like the bill. As I said before, when we were talking about the other legislation, one size doesn't always fit all, and what works in one area may not work in the other. And I think our municipalities should have a right to determine for themselves, if they don't want vacation rentals or they do, that should really come from those localities. But irrespective of that, as long as our associations are protected and as long as we still have that language in there that allows us to deal with these issues in our documents, then I think we're going to be okay. So the latest versions have that, so we're okay with that. But it does dovetail into an important discussion about the long-term leasing issues that came down the pike last year for HOAs. And if you're a condo owner, you remember maybe 10, 12 years ago or so, I don't even remember how long ago it was, but 718 was amended way back when to have some language in there protecting existing owners with regard to certain types of rental amendments. So if you're amending your declaration as a condo and you're trying to prohibit renting, or if you're trying to change the number of times a person could rent or the minimum lease term of a rental, you could only do that as to those people that voted in favor of it and therefore bound themselves to that change, or to those people who took title to their units after the change went into effect, after the recording of the declaration amendment. So it's basically a way to grandfather existing owners who didn't vote in favor of those restrictions to not have to deal with those restrictions, but their future buyers or other people that acquire title to their unit would be subject to those changes. HOA 720 never had that language in it, although for many years there were threats to put that language in 720. It never made it in there until July 1 of 2021. And in a really bizarre way, it's in there, and it's in there in a completely differently phrased way than it is in 718, which again, Travis, this is something I think maybe for a glitch bill in the future or something, because if the goal is to make 720 and 718 similar, then I don't understand why they didn't just use the same language. And we maybe want to try to fight them to do that at some point. But the important key now for our HOAs, where we used to be able to tell our HOAs, don't worry about it, do your rental restrictions, they're going to apply to everybody. There's similar language now that certain types of leasing restrictions, and I think the language now in 720 is any amendment that regulates leasing agreements will only be effective as to those people that voted for them or that took title to their units after the fact, with the exception of restrictions that would restrict short-term rentals, such as rentals for less than 30 days or more than 3 times in a calendar year. So in a strange way, the HOA law now basically says that rental restrictions will only apply futuristically or to those that voted for it, except we're going to allow you to do short-term rental restrictions. But condo now says that only certain types of leasing restrictions will apply to those who vote for them or to those who purchase afterwards without that carve out for the short-term rental. So it's just a very strange situation now where you just have to be very careful and consult with your association's attorney if you're trying to do rental amendments, because number one, figuring out which rental amendments you're going to draft and which ones are going to be, enforceable, and who they're going to be enforceable to, and whether we have to draft them prospectively or whether they can apply to existing owners. So just something to keep in mind when you're drafting your amendments. And the only other piece of advice I would give if you're drafting amendments, even though the legislature does now say, or if this bill does go into effect at some point to allow for short-term rental restrictions and gives the carve out for associations, if you're going to draft your restrictions to prohibit vacation rentals, do it specifically. My advice would be actually call it vacation rentals, leases, licenses, because I'm hearing a lot from the vacation rental industry that they consider what they're doing to be licensing as opposed to renting, and therefore they're not subject to any rental restrictions in a declaration at all. So when I'm doing amendments now, and I'm sure Marty, you're seeing the same thing, and all of our colleagues, call it what it is. Do a restriction that says we prohibit any time sharing vacation rentals, whether by lease, license, or whatever, and you'll be in much better shape.
Great. And what passed last year and went into effect in July did not, it was not retroactive in the sense that it didn't undo anything that you already had. So if your books, if your documents said, this was our, this is the way we operate here, that was not undone. And some of the vacation rental bills in the past and going forward, they kind of rotated the clock back as far as local government rental restrictions. They said, after 2011, the ones before 2011 would be grandfathered in, but everything else that had passed after that would be repealed. This did not do that. Marty, do you have anything to add on that before you go into rising insurance costs?
No, I mean, leasing amendments are always great at the outset, and I do think they're beneficial, but they're very difficult to manage, especially when you have that opt-out where it doesn't apply to people who don't vote or vote against it. Over time, you will capture everybody, but it's also hard to counsel as to not be a knee-jerk reaction, because typically I find myself trying to help associations out, and you're trying to curb the behavior of a few bad apples without hurting the majority that are actually compliant. And it's a very delicate balance. And so I try to make sure that we sit down with boards and have those conversations of what are you actually trying to do? And let's make sure that we're aiming it correctly and not being sweeping in a way that's really detrimental and oppressive. So that's kind of the way I feel, but everything else with Steve, I agree with what he's saying. It's different versions, different times. I like to see that the HOA and the condos are starting to look more and more alike. I think it helps. It helps avoid confusion and frankly abuse. So,
Gene, thank you. And there very well could be a special session on insurance because we are losing companies, and there's more coming between now and June 1st, which is a hurricane season, but also when a lot of these companies have to go out and get reinsurance. We already, we lost another couple last week. It used to be when your agent would go out to bid on your commercial residential, master policy, not your HO6 policies, but the association's policy, they would have 12 carriers that would be fighting for that business and responding. Now, there's like 2. It's very, very difficult. Everybody's getting pushed into either the surplus lines market or Citizens, et cetera. That is something you could take up with your agent. Gene, as we said earlier, that statute got changed this year in 518. If the governor signs it and doesn't veto it, that statute will be changed regarding tree pruning. Steve, do you want to answer? Can you see the question?
Yeah.
It's under Q&A. Gene is asking.
That's the current version of 163.045, which says that you can't require the permit and application process for residential property. What the new law would do, and I would suggest, Gene, if you want to just Google SB 518 Florida, and it'll bring you to a link to the proposed new law that passed both houses. And it actually adds language to that, and it adds a definition of what's considered residential property to solely relate to the individual lots and homes in a single family and not the common area. So that's the concern.
All right. So that one's keeping up. All right.
Yeah.
Okay. So, Tony, I'm going to hit it. I think, return it back to you, unless you want me to talk about, like I said, some of these bills dealing with fines and flags, which would have impacted HOAs as well. They did not pass, but they're things that could come back if you want me to. It's up to you.
Yeah, Travis, I think maybe take a few minutes to comment on those things. I think we've done a great job of hitting the questions that came in during the presentation. If there's anybody out there that has some questions now you'd like to submit, go ahead and do so. If we don't get to them during the presentation, we'll certainly get a response to you afterwards. Patricia had a question here, Travis. I see we had 27% in insurance this year and only 3 companies.
Oh, wait.
As Travis mentioned,
Yeah, right.
that's the problem. You know, we've got.
Yeah, yeah. I mean, I think you're looking at a minimum of 20% increases. So I've been in, at board meetings over the last few year, let's say, and as I'm waiting my turn and the board is getting their bad news from their insurance agent first, these agents are saying, I would put into your budget, as you guys are creating your budget, I would put in at least at a minimum, a 20-25% increase in your insurance line, which, is another reason why, again, all of these things that we're talking about, there's a balance. And I think Marty mentioned this. I think both of our panelists mentioned, and there's a balance. And, we don't want to do something that, yes, we may create all kinds of, the Rock of Gibraltar, type of an association, but if nobody can afford to live in it, now we've created another problem where people are just handing over their keys and saying, I'm out, I can't afford a 300% increase in my monthly assessment. So it's a balance. So there were, I'll talk real quick about fining. There were a couple of bills dealing with fining. I'll just use one as an example. One would have set up an ombudsman program for HOAs. As you know, right now, the ombudsman program in the state only exists for, it's a condo ombudsman. I would have just taken that same program and expanded it to include HOAs, but they were setting up a whole new one, which is, I think, duplicative government, and it would have cost a lot more. And they would have taken the money from for HOAs would not have paid into it. They would have taken the money from the trust fund that condo owners are paying for. So condo owners would have been paying for their own ombudsman, for their own arbitration program, et cetera, et cetera. And they're $4 a door. But then they also would have supplemented and been paying for the ombudsman for HOAs, and we didn't like that. And then for fining, it would have set up so right now, if you decide that you're going to fine, and this is going to be very basic, but if you're going to fine, you have to set up a fining committee. So your fining committee, which can't be your board. It's got to be separate from your board, and your fining committee cannot change the amount. They can just say yes or no. So the fining committee is if you say it's going to be $1,000, they can't say we'll take $750. What this bill would have done would have set up a appeals committee that is not the board, not the fining committee, can't be related to anybody that's on the board of the fining committee, an appeals committee, which I'll use my association. We're set up as a 720 townhome community. We have 24 units. I'm the president. I went to the turnover meeting, kids. That's what you do not do ever on the Zoom. So I'm the president of the association. We have 5 board members. We were only supposed to have 3, but somebody wanted to be involved. So of course we expanded it to 5. So now we have 5 board members. We're new. We don't have a fining committee, but if I had to set up a fining committee of, people that are not part of the 24, so then you take away the 5 board members. So now you're down to like 19. And if I have to set up a 3-member fining committee, and then this appeals committee would have been 5 members. I mean, I've run out of people that are not, related, cohabitating, involved with. I mean, I don't have the. So it's a craziness. And then it also said that this fining committee would have had the ability to say, we'll take a different amount. And so I'm like, either give that ability to the fining committee, but the fining committee is kind of the appeals committee. So I'm like, this isn't ready for prime time. It needs some work. So then there was that issue. There's a whole bunch of other issues that would have not allowed fines to become liens, et cetera, et cetera. The other issue on flags, and I'm not getting political. I don't care what your political affiliation is, any way, shape, or form, but communities, we try to have them exist harmoniously. If you've been paying any attention, flags have become kind of the new political signage. So we have a lot of things that say what you can do with and without political signage in a community. This would have said, and right now the law says, you can, let's use as HOA as an example. You can have the United States flag, certain size. You can have a sign of the branches of the armed forces, which, by the way, we did add Space Force. The Space Force bill passed. So the United States Space Force is now one of the armed forces. And then, so on like Memorial Day, et cetera, you could have, and it's kind of, it provides some flexibility, but it's restrictive, but allows associations to have some say. Well, this would have said, nope, associations cannot say no to flags, and dealing with law enforcement, dealing with first responders, dealing with this, that, and the other thing. And so it just would have become, again, I don't care what your political affiliation is, what your groups are. What I do care about is that you agreed to live to some rules. You agreed to abide by the rules, and you also agreed that the rules could be changed. And if you don't like your rules, then go start knocking on your neighbor's doors, do whatever you want to do and get the rules changed. But what I don't think the legislature should be just saying, we're changing the rules. And especially when it comes to flags, because it'll get crazy. So again, just an example of somebody that's just walking the halls, looking after your interests. I just get very passionate about community associations and common interest ownership. And we have a lot of legislators that don't understand common interest ownership, don't understand community associations. So it's all of our job collectively to be that advocacy arm to educate them.
Travis, let me just jump in real quick. I mean, how many times do you see this as a lobbyist where you hear a story about a legislator that personally is affected by something? Maybe they get a violation letter from their association, and they turn around the next day and they file a bill to deal with their pet issue. I mean, there's the problem is there's a lot of these legislators that really don't understand the concept of HOA and condo. They need to be coming to people like us to really understand that, but they're also using this as a platform to deal with their own pet issues. And I think that's something that needs to get curbed somehow.
Right. The legislator that filed the fining bill is suing his association currently on an issue dealing with the political signs from his last campaign. And so, yes, that is correct.
So one of the questions that I see here is why don't HOAs pay the $4 per door as condo associations do? That was a subject of a proposed bill this last session where the legislature proposed that there'd be an ombudsman for HOAs, similar to what there is for condos, but there was no mechanism to pay for that infrastructure. So that's a very good question. Maybe the initial thought was condos need more oversight than HOAs do, but I think most of us would agree that that's not necessarily the case. So there really isn't a good answer. I mean, eventually, I'm sure we will see that HOAs will be paying, a fee to finance regulation by the Department of Business and Professional Regulation. Travis, thoughts?
Yeah, it's a political thing because they would look at that. Somebody would look at that as a neighbor tax, because what would happen is somebody would say, okay, HOAs are now going to pay $4 a door. So then they would take a look at the, thousands of let's say you're running for office in, Palm Beach County in an area that has a ton of associations, HOAs. They would say, Representative Rappaport, they would just do the math and the mail piece would come out saying, $4 times how many doors are in that. And they would say, Steve Rappaport supported a neighbor tax for $27 million or $207 million, probably more like it. And you guys would get that mail piece and you would be like, I'm in an HOA. I don't want a neighborhood tax. What's that? You wouldn't know what it was for, what it did. You would just see a big, huge number and see that Representative Rappaport did it, raised your taxes, and you would vote him out of office. So they're terrified. So they will not. I remember years ago, Tony and I dealing with a senator who is actually no longer even living, and it wasn't because of that. It wasn't because of Tony and I dealing with it. Yeah. But that didn't come out right. But we were saying, look, because this money's being swept away for condos, let's reduce it down to like $2 a door or get rid of it for a few years. Because you've got a bunch of money and you're using it for all kinds of other things. Let's just say, put a pause on that or reduce it. And she said, no, because if we ever reduced it, we would never be able to put it back because of what I just said. Then it would look like, oh, that's a tax increase on, that's a condo tax. And so it stayed where it is. And then we just had to have them use the money properly. But so real quick, Anonymous asked, and I was going to type an answer, but you guys I have 3 attorneys who know the answer. The statute says you cannot fine more than 25 per issue, correct? I'm like, I don't know who Anonymous is. This might be, could be, but that is not correct. And first of all, it depends on if you're an HOA or a COA, but Steve,
Sure.
What do you think?
Well, yeah, I mean, first of all, it's not $25, although I always tell everybody, look at your documents first, because even though the statute sets up the minimums and maximums, your documents may be more restrictive. So, but what the Condo Act says is you cannot exceed $100 per violation or $1,000 in the aggregate if it's a continuing violation, period, end of story. HOA 720 says you cannot exceed $100 per violation or $1,000 in the aggregate unless otherwise provided in your governing documents. So look to your documents. You can amend your declaration to add higher amounts of fines if you're an HOA, but also look to it because your declaration might say you can only charge $50 a violation. And then you have to go with that because your documents can be more restrictive than the statute. But the statutory limits are 100 and 1,000 for continuing.
Well, and just to add on to that, the HOA, you can actually lien if you hit that $1,000 mark.
Yep.
But what I typically say is you don't want to foreclose a home for $1,000 fine. And with respect to condominiums, at the end of the day, what I try and counsel clients on is this isn't about dollars, it's about behavior. And so sometimes a suspension of use rights is a better tool than a fine. And for some of these, multi-million-dollar condominiums, $100 is the cost of doing business they don't care about. So I think it really becomes important to try and figure out exactly what you're after, because the fine in that process and trying to find enough volunteers to sit on those committees, it may not be worth it, and maybe try and find another solution to get where you're going.
Right. And there was a bill dealing with just that on fines that got filed because the sponsor had constituents, and her thought was, I don't think that they should have a lien put on their property, their home, or have their home foreclosed on because you didn't bring in your garbage cans quickly enough. So, I mean, you're right. But we were like, well, it's a tool that is there for behavior. So if they're renting out their house for, $1,000 a week, and they're going to be like, all right, find me $1,000. I mean, I'm making $52,000 a year on this house. Great. So, Richard asked a question and I accidentally, instead of answering, I put in the word yes, but I deleted it before I sent it. So now I can't get back to it. So anyway, aside from increased rates, have you seen insurance companies ask for mandatory items, conditions of the building, impact glass, et cetera? And the answer is yes. They're asking for all kinds of stuff. All right, I think Kirk asked, I think it's the last one that we didn't answer because they're everything. But Kirk said, for HOAs, do the docs still supersede Florida Statute 720? No.
I mean, the short answer to that is no, they don't. It doesn't supersede. Your documents can be more restrictive than the statute, but if there's a conflict, right, then the statute supersedes over your documents. So, right, for example, just as an example, if your documents say that proxies are good for 11 months and the 720 says proxies are good for 90 days, proxies are good for 90 days because that's state statute and that's a clear conflict. But if the state statute says you can fine up to $100 a violation and your documents are more restrictive and say you can only fine for up to $50 a violation, then in that circumstance, because it's not a conflict, your documents are actually being more restrictive than the statute, than the documents would control. So it depends on the circumstances.
Okay. All right. I'm closing this question thing because more will happen. And if I can't see them, all right. Tony.
There was one question, Travis, about rec lease. I don't know if Marnie or Steve want to go there because it's a topic from the past that unfortunately still lingers for some communities. But the question was, is anything being done because of, Fannie Mae or Freddie Mac's, restrictions on financing in communities that have rec leases,
That's a dinosaur that just needs to go away.
Yeah.
I don't really know what the answer is to that, other than trying to really prompt that rec lease. They all have counsel trying to get them to act. I don't know that you would be able to supersede it, other than trying to explain to the lender that there's a rec lease in place and it's paid and so forth.
Well, listen, I want to be sensitive to everyone's time. We would certainly want to thank Marnie and Steve for being with us. Travis, as always, your insight is invaluable into this crazy process that happens once a year. Thankfully, only once a year. Hopefully, a special session. It may happen again soon. But I do want to thank all of you guys for participating. And those of you who also attended the webinar today, we want to thank you for your time. What we do legislatively is very important for us on behalf of our community association clients, and it's something that we'll continue to be actively involved in, and we encourage you to be engaged in the process too, because we can speak, Travis can speak, but nothing is more valuable in the legislative process than for legislators to hear from you, their constituents, the people who actually vote. So keep that in mind and keep involved in the process as we go forward. You can go on our website and we'll have a recording of this session there available if you care to look at it again. Also for articles of relevance, also our website, we regularly update with things of that nature. I'd like to thank you all again for being with us, and hopefully you'll enjoy the rest of your day. Thanks.
Thank you all.
Thank you.
Thank you.